This is the first recording of several looking into the rules governing international treaties. I have also added as attachment the slides to this presentation where you can find in notes added resources and added readings if you are interested in exploring a bit more some of the issues that are outlined here. It starts explaining the relevance of the Vienna Convention on the Law of Treaties. Then we provide the standard definition of treaty, and we conclude with the formalities that are necessary for the conclusion and entry into force of international treaties. When we study treaties or when we look into cases that make references to international treaties, it is normal to find multiple references to the 1969 Vienna Convention on the Law of Treaties, which is itself a treaty that regulates how treaties are concluded between states. We also find sometimes references to the 1986 Convention on the Law of Treaties, this one focusing on the conclusion of treaties between states and international organizations or between international organizations. Both these instruments are treaties, and while we all make reference to them, and it is normal to explain the full topic of treaties making reference to this treaty, particularly the 1969 Vienna Convention on the Law of Treaties, it is important to highlight that these treaties are not compulsory for all the states of the international community and none of the international organizations as treaties. However, their articles, their provisions have been in their majority accepted as customary law. Okay, so I have provided there two screenshots of the status of ratification of both conventions. As you can see, the 1969 convention that regulates the conclusion of treaties between states has 116 states parties and entered into force, which means it became binding for states that are party to it in 1980. On the other hand, the Vienna Convention on the Law of Treaties between states and international organizations or between international organizations is not yet in force. It has 44 ratifications, 44 states that have accepted to become parties to this treaty. However, it needs 55 to enter into force. However, as I said, there are several cases of the International Court of Justice, and in general, proclamations, acceptance, states accept that the provisions that are codified in these two treaties are illustrative of international customary law. To simplify the presentation, I will be mainly referring to the 1969 Vienna Convention of the Law of Treaties, just because its content is very similar to the 1986 Convention, and as I said, both of them are codified expression of customary law. While they capture the practice that the states normally follow when they enter into treaties and when they conclude treaties, the drafting of the Vienna Convention of the Law of Treaties is owed or is credited mainly to 4 British lawyers, 3 British, 1 based in the UK, Lauterbach, very famous lawyer, all of them are very influential international lawyers. When they drafted the convention, they had very much in mind the contract law design scenario, and therefore sometimes it is difficult to apply the convention provisions to treaties that are not regulating contractual obligations between states, that are not based on reciprocity. As we will see, this is particularly relevant for the case of reservations to treaties. The Vienna Convention on the Law of Treaties are, in general, drafted very clearly and it is not a very long convention, so I highly recommend that when you are studying the legal regime of the Law of Treaties, you always have at hand the Vienna Convention on the Law of Treaties itself, because it's probably one of the easiest way of understanding treaties is just to read the Vienna Convention on the Law of Treaties. So what is a treaty? Article 2.1 of both conventions use a similar definition and define treaties as an international agreement concluded between states, or in the case of the 1986 convention, between one or more states and one or more international organizations, or between international organizations, in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. We are going to have a look at each one of these elements that together make a treaty. First of all, it needs to be a written agreement between two or more parties and intended to create legal relations. The denomination is not relevant and it should be governed by international law. Let's see what that means. Well, it needs to be written, which doesn't need more explanation. It also needs to be between two or more states and or between international organizations or between states and international organizations. It can be a bilateral agreement between two states, between one state and one international organization, or between multiple states and one international organization, or as the example I am giving there, among several states that want to create an international organization. They normally do this, normally not, that's how they do it. They do it by adopting a treaty that in those cases is normally called a charter, but it's basically a treaty. But what happens with other kinds of international agreements between non-state actors and between other states that are not international organizations? I have added here a couple of photographs. One it's representing the signature of the Waitangi Treaty between the Maori and the British Empire. Another one more recently between the FARC, a non-state militarized group in Colombia, and the government. What regulates these treaties that are not concluded between state actors or with international organizations? The answer is complex, and we will see examples of this, for instance, when we look at the Chagos case. But to answer in the simplest possible way, it will depend, and you will need to look at it case by case. The typical example is definitely peace agreements, many times signed with non-state parties that are considered binding at international level. Another element of the definition tells us that whatever the name we give to the treaty, to the final agreement in written, it needs to intend, the aim of that agreement is to create legal obligations. So basically it's telling us that the content is more important than the name. I have provided there another photograph of the governmental representative that signed the final act of the Conference on Security and Cooperation in Europe in 1975, which is the typical example of a very important written agreement that fits almost all the requirements you can expect from a treaty. However, it's not a treaty because the states that were there represented didn't want it to be anything else but a political understanding, a political agreement without legal force. However, it is also possible that we find other instruments that don't look like a treaty, that are named in a way that would suggest they are not intending to become a treaty. However, when we look into their content, it is clear that they aim at creating legal obligations. The International Court of Justice has decided in more or less controversial cases that, for instance, press communiques where states have made a commitment to accept the jurisdiction of the International Court of Justice were binding as treaties. So even if they were called a press communiques, they are really a treaty and the name was irrelevant, as the definition tells us. Another very convoluted case that contains many other issues related to treaties and where the International Court of Justice proclaimed that the Vienna Convention on the Law of Treaties was applicable to the case despite the fact that Qatar and Bahrain were not parties of the convention, despite the fact that this was contested. The International Court of Justice didn't even bother to explain that it was applicable as customary law. It was just presumed that this was the case and the Vienna Convention was applied. But apart from that, for what it concerns us now, the most important thing is that there was part of the dispute was about whether or not the summaries of a meeting could be or not considered a binding treaty. On this occasion, again, the International Court of Justice looked into the content of that meeting and concluded that these were not just a summary of what had happened in that meeting, of the positions of the states, but the written representation, the written articulation of a consensus reached by both parties on several points, among them one by which the parties agreed to bring their dispute before the International Court of Justice. And this was considered a treaty for the purpose of bringing the case before the court. Finally, a treaty needs to be governed by international law, which means is that that written agreement that intends to create legal obligations between two or more states or between states and international organizations need to follow some formalities for it to be considered a treaty and therefore binding under international law. Mainly, we can divide these formalities in two phases if you want. An initial one where states negotiate and follow different processes until they end up with a final text everybody is happy with, and then once they have a text they can decide whether or not to express their consent to be bound by their treaty, and that's what I have called here the final phase. In bit, we have an initial phase where you have states, international organizations negotiating until they are happy with the text, they adopt it, and then they proceed to what we call authentication of the treaty. That makes one obligation arise, the obligation not to frustrate the purpose and object of the treaty. Many times, once states are happy enough for adopting a particular text, they cannot immediately express their consent to be bound by their treaty, but the representatives of the states in the negotiations or in the adoption and authentication need many times to go back to their home treaty and see if they really want to become parties of that treaties, if they really want their state to be bound by that treaty. And in that case, they will enter into the final phase by which states express their consent to be bound by the treaty. They then normally deposit and publish the treaty that enters into force. As we will see in other presentations, the entry into force can actually happen before or after the consent to be bound is expressed, but in any case, no state is bound by a treaty until the moment they consent to be bound by that treaty. They might have participated in negotiations, they might have voted in favor of the adoption, they have authenticated the treaty by signing it, but until they express their consent to be bound by the treaty, that treaty is not binding for their state.